Welcome back to The Weekend, everyone. New this morning, Donald Trump telling lies. Well, that's actually not that new, is it? And he's lashing out at the federal government in his first interview since being convicted. 34 felony counts for falsifying business records. Take a listen.
It's a scam. And the Republican Party is really, they stick together in this. They see it's weaponization of the Justice Department, of the FBI. And, you know, that's all coming out of Washington. You may think it's brag. Take a look at who opened the case. I'm not allowed to talk about it because I have a gag order.
Joining us now is former FBI General Counsel Andrew Weissmann. He is a law professor at New York University. Also with us is MSNBC legal analyst Mary McCord. She is the former Principal Deputy Assistant Attorney General for the National Security Division. And Andrew and Mary are the co-hosts of the Webby Award-winning podcast, Prosecuting Donald Trump. All right.
Good morning, friends. We talked about attacks on the justice system, and I do want to get to that. But I think it is important to underscore that in addition to attacking the judge, to attacking DOJ, to attacking all the institutions, he's also attacking the jury itself, right? These are just average citizens who did their civic duty, and he is still going after them in the aftermath.
So one of the things that is notable is that this jury sort of valued and honored its oath more than lots of people in the United States Congress and certain judges and justices. I mean, they really stood up and just did their job. It is normal for a defendant to say it was unfair. I mean, that's what they do. They don't usually own what they're doing when they go to trial. So for Donald Trump to say that is fine. It's false, but it's like that's what defendants do. But the tell is that if he really wanted to sort of say, you know what, this is all a witch hunt, why is he delaying 3 other trials? Why doesn't he say, you know what, those Florida jurors, they're going to be my people. Well, why he's not going to trial, doesn't want to go to trial there, doesn't want to go to trial in Georgia, doesn't want to go to trial in D.C. That is because of what just happened in New York, which is a jury of 12 people picked, with his input, found unanimously beyond a reasonable doubt. And for those of us who are in the courtroom, it's easy to put a label on this and say, oh, it's unfair and it's rigged. But let me just give you one example. David Pecker, his friend, was largely uncross-examined by Donald Trump. At no point did he say he's lying. And he said that we had this conspiracy to fix the 2016 election.
It's crazy. It's so, Mary, let's talk about the new felon in our midst, because I think it's important to point out that Donald Trump is a felon. That's F-E-L-O-N, for those of you who need that help. The New York City Probation Department is going to conduct an interview and generate a sentencing recommendation for Justice Merchan. This will be a moment where Donald Trump essentially confronts not just what got him into this situation, but his whole life story. This aspect of this process is very, very probing. During that interview, a convict can try to make a good impression and explain why he or she deserves, a lighter punishment. I was a good member of the community before this happened, all that stuff. But it is a chance for them to create an impression as Judge Merchan decides to, mete out the punishment. How do you think that's going to go?
Well, I can hardly imagine, frankly, Mr. Trump sitting for that interview and it going well. But one thing that's so different about this case than the cases of so many individuals who do have this interview before they go to sentencing, and for who it is so important, is that we know so much about Mr. Trump's history, right? I mean, the whole country does, the whole world does. And normally, it's much more common for a defendant who's gone through a trial, who's been found guilty by a jury, that the probation officer and the judge don't really know that much about the defendant as a person other than their crimes, right? The things that the evidence were put on about at the trial. So it's always important to be able to convey what their upbringing was like, what their education was like, what challenges they faced in life, what challenges they overcame in life, right? Whether they are thought by others in their community to be good people, whether they've expressed remorse, et cetera, et cetera. We don't kind of need that for Donald Trump. That's already known. It seems, to my mind, almost a little silly to even go through this process with respect to him. But when we do get in front of, when he does get in front of Judge Merchan, I mean, the things that typically somebody would get credit for, I just think some of those things will be lacking. Things like accepting responsibility.
He's saying, Mary, the man is saying to play the side, please, because Donald Trump is claiming he did nothing wrong. He said it today.
The judge could decide to say, hey, house arrest or even jail. How do you face what that could look like?
I'm okay with it. I saw one of my lawyers the other day on television saying, oh, no, you don't want to do that to the president. I said, you don't beg for anything. You just, the way it is.
The other one I wanted to play was, he said, I did absolutely nothing wrong. Yeah. Think of it.
So, you know,
that doesn't sound like men that's sorry.
He's entitled, as a matter of his appeal, to be contesting, you know, that the guilty verdict. But accepting the jury's, you know, rendering of a verdict, that is something core to our system. Mm-hmm. And, you know, the judge will be also looking at things like, you know, the reason for the scheme. The judge will look to see, you know, what other cases, what kinds of sentences have been meted out for falsification of business records, and what were they falsifying them for. Oftentimes, the motive for that is financial gain, right, to yourself or to somebody else. Here, it's completely different. It's undermining the results of a presidential election. So very significant. So there's many, many things the judge will be looking at, but I have a hard time thinking that interview with the pretrial services folks is going to be that meaningful.
It's going to give way to a lot.
You should feel free, Andrew Weissman, to weigh in on this question of sentencing, but I am also curious, given that Mary referenced appeal there, if you think there actually are any grounds for appeal.
Well, the grounds for appeal, it's hard to see that they're terribly meritorious.
Right, because what they're going to say is that the judge had a conflict of interest.
Yeah, that's already been ruled on.
Right.
You know, this is a de minimis amount of money. I mean, we're talking about less than $50. And, you know, it's a mistake. He should not have done it. But it's already been decided. So that's just not going to go anywhere. And the one thing I would say is for those people who were in the courtroom, I mean, obviously there's a transcript of everything, but if you were in the courtroom, this judge was so remarkable. The idea that $35 made any difference, I mean, he was so careful and ruled, you know, in favor of Donald Trump on all sorts of things.
In part because of an awareness about the fact that this could move to appeal.
Oh, yeah, absolutely, to make sure it was a clean trial, but also I think just out of, you know, he has a different role. His role is to be a judge, which is to be impartial and to, you know, weigh and assess what is fair to a defendant. That is what his role is. And so I don't think that's a terribly good ground. I think there'll be some legal grounds about the nature of the charge. I think factually, that's where I see it being the weakest for, you know, making any sort of claim here. The judge, you know, is so experienced and it's also so well respected.
Well, the argument we're going to hear, just because here's the thing, people are going to be around their kitchen tables with Trump supporters who are going to repeat everything that they're hearing from Donald Trump and from his allies. So let's just get into it, which is one of the things they're going to say is, well, this was weak case law. Right? This is so thin. This is so shallow. How is it possible that the first person who's brought up on this is the former president of the United States?
Okay, so not the first person. False business records are charged all the time. It is true that, you know, I was responding to this on Friday where someone said, oh, but these charges were sort of tailored to Donald Trump. And I'm like, all charges are tailored to the defendant. I mean, I was like, what does that mean? I was trying to relate it to, I used to organize crime cases when we prosecuted Vincent Gigandi under RICO. Guess what? Those charges were tailored to the facts. When we looked at Enron, the CEOs, those charges were tailored to those facts. So here, as Mary alluded to, these charges, the false business records, are tailored to these facts. And frankly, as Mary said, these facts are much, much worse than most false business records because the scheme that the jury found, just to be clear, beyond a reasonable doubt, was interference in the 2016 election. That was the goal, and that had to be found by the jury. beyond a reasonable doubt. So I think that sort of claim of this is, unique and different and somehow unfair, that I think is going to fall on deaf ears. And it's just to be clear, it is so disrespectful of jurors. I mean, what they're really saying is that 12 people, just average American citizens, you know what, we should just disregard because somehow, even though we were not in court, we know better than jurors who took an oath of office, and they should be disregarded.
Mary, the next phase of this, Andrew's touched on it a little bit already. This gets up to an appeals process. What does DA Bragg do? What does this office do at this point? Are they still engaged at that level? Or is that going to be driven more by the defense going and making the case versus what we saw in the trial where the prosecution was making the case?
Yeah, it's up to the defendant is the one who will appeal here. Note the appeal. The defendant will have the opening brief. And because it's up to the defendant to decide what issues he's taking up to the Court of Appeals. And I handled appeals for nearly over a decade in the U.S. Attorney's Office defending convictions, right? And so what you do then as the prosecutor and what the DA's office will do is their brief will respond to what are alleged to be the errors pointed out by the defendant.
Original case.
That's right. And, one thing that's important to keep in mind is that, there might be lots of possible things that a defendant could appeal on, but they really need to choose the ones that are sort of load-bearing, that would make a difference, So even when there are errors, maybe an evidentiary error, they doesn't necessarily mean a conviction is reversed. The error could be harmless, right? And so you want to go for the defense is going to want to go for the type of errors that it thinks that if it prevails on will result in a reversal.
I just smirk, Michael, because what Mary is saying is the defense has to be strategic.
Yeah.
And they not good at strategery on that side of the fence.